Hi, everyone. Welcome to our webinar hosted by our Women's Health Working Group here at McGuireWoods. Today, we're going to be talking about key regulatory topics and recent developments in women's health. But before we get started, I know a lot of people that are dialed into the call know myself and others at McGuireWoods, but we also have some new faces on the call. So just to give a little bit of an introduction for everybody that's joining us, my name is Kayla Marty. I lead our Women's Health Working Group here at McGuireWoods as part of our healthcare department. For anyone that's not familiar with McGuireWoods, McGuireWoods is about a 1,200 plus attorney firm across the country, across the world at this point. In healthcare and private equity are a core area of our practice here. So we have about 50 plus attorneys that sit alongside me in our healthcare department, and then about 100 more healthcare related attorneys throughout the firm, whether it be in benefits or tax or debt finance or general corporate. And so you may have come across one of them in your businesses, and we want to invite you at any time to feel free to reach out to us if you have questions or you want to talk about anything that we go over on the call today in greater detail. Because we only have 45 minutes to an hour, we're going to hit things at a pretty high level and a pretty large breadth of topics to let you know some of the things that we are seeing in the market, some things to be on high alert for as you all operate your businesses. I know many on the phone are lawyers, just like Sydney and I are. So for those of you who are getting CLE credit for this, if you have any questions, please feel free to email us after the presentation. This is being certified for CLE, and you should have been able to register with your CLE number at the beginning of the presentation when you registered. And for those of you who want access to the slides or want to be able to rewatch certain parts of the content, those will also be posted on our website as well as emailed out to the group following the discussion today. So if you want to reference anything, we'd love to have you. The last opening point that I'll mention is, in addition to our webinar series that we do throughout the year as part of our Women's Health Working Group, we are also hosting a Women's Health and Wellness Investment Summit here in Charlotte, North Carolina, where I'm based, on September 27th. If any of you are interested in attending or anyone on your team is interested in attending, we would love to have you. Please do not hesitate to reach out. We'd love to get you registered. We'd love to have you as a part. It is for a half-day session, like I said, on September 27th, before our Healthcare Finance and Growth Conference, which is not only women's health specific, but is focused on providers in the healthcare space on September 28th here in Charlotte. And we will expound on some of these issues during that discussion and hope to have some more key updates for you. But with that, I'll just jump right into our agenda. So our agenda today is several key topics. It may seem to you that this is a little bit of a hodgepodge of different issues, and that's exactly the intent. The intent is to give everyone on this call the updates, the things that we're seeing, the things that our clients are struggling with, things that we're seeing other people in the market struggle with. And we're going to talk about antitrust. We're going to talk about Stark and Kickback. We're going to talk about some updates with respect to HIPAA and privacy rules, all things designed to keep you as up to date as possible on things impacting women's health. Obviously, for you on the call, women's health is a huge topic. It is OB, fertility, menopause, cancer care, gastroenterology, you name it, across the board. So I'm sure for people on the call, there's going to be some things that are highly relevant to them. There's going to be some things maybe they don't face as frequently in their businesses, but just hang with us. I think you'll get a lot out of this session. So with that, I'm going to turn it over to Sydney to be able to cover our really recent regulatory updates on reproductive health, fertility, surrogacy, some Impala issues, and hopefully those will be very productive for you. Sydney?
Thanks, Kayla, and hi to everyone listening. My name is Sydney, and a little bit of background. I am an associate with the McGuireWoods Healthcare Group and a member of the group's Women's Health Working Group. I'm really excited to be here with you all today and appreciate you tuning in. So as you will see on this slide, I'm going to provide a pretty high-level overview of some of the recent regulatory developments that we're seeing that are or likely will have a significant impact on women's health. And we'll specifically be focusing on, first, some recent changes in the law affecting a person's access to reproductive health care. Second, we'll go into some access to fertility treatment and maternity care issues. Third, we'll talk about the legality behind traditional and gestational surrogacy agreements. And finally, an evolving discussion on Impala post-Dobbs. And I'm going to go to the next slide now. All right, so I know most of you on the call are probably already aware, and many of you probably have a pretty deep understanding of the Dobbs decision and its implications on women's health, as it has been pretty well reviewed over the past year. But we do just want to provide an update on where things stand and the things that you should be aware of, since the implications do kind of extend past just abortion and into other reproductive health-related issues, many of which I will touch on in a later slide. Now, the Supreme Court codified an individual's right to access abortion in Roe v. Wade and reaffirmed in Planned Parenthood v. Casey. And then after 30 years, in June of 2022, the court overturned this precedent from Roe and Casey in the case of Dobbs v. Jackson Women's Health Organization, effectively ruling that such access and restrictions should be left up to individual state legislatures. Now, in Dobbs, the court upheld a Mississippi law that banned abortion after 15 weeks of pregnancy, and in effect, this holding eliminated all national constitutional protections for abortion and ruled that moving forward, all abortion laws and regulations will be entitled to a quote-unquote strong presumption of validity. Now, following this decision, an increasing number of U.S. jurisdictions began enacting abortion laws that ban or restrict abortion and impose potential civil, criminal, administrative liability on people who are involved in seeking or providing abortion-related services. And while some states have banned nearly all abortion-related services, other states do allow for some narrow exemptions to safeguard the health of the pregnant person, or also in some cases to allow abortion up to a certain point if the pregnancy is caused by rape or incest. We are seeing that in some states, the disagreements over abortion access is being litigated in the courts. And in these states where litigation is still ongoing, abortion remains legal as courts determine the legality of those state laws. Still also, we are seeing that other states have actually enacted legislation expanding access to abortion by adding certain legal protections to their state statutes. This lack of consistency across states has led to many providers undoubtedly questioning whether they're allowed to perform abortion services or not, and under what circumstances. And this confusion has occasionally, resulted in delays in providing services, sometimes even when those services are medically necessary. And so without clear guidance, many providers are left feeling, kind of fearful that they may potentially violate their state's abortion law. So it's really important that all providers who perform these types of services remain abreast of, this really changing legislative landscape in the state where they practice. There's also some concern over how the Dobbs decision will affect people in the U.S. who are already facing obstacles, who already face obstacles to accessing safe and effective health care for different reasons tied to either low finances, disability, status as an undocumented citizen, living in a rural area, and even discrimination based on race. And in addition to these concerns strictly regarding abortion, restrictions and bans on abortion may also have a less evident impact on pregnant people's ability to access other reproductive health care services, including fertility care, services related to managing a miscarriage, and care required for certain pregnancy complications. So if you have an OB clinic and you're considering expanding abortion services, or if you're actively purchasing clinics that provide abortion services, it's always a good idea to reach out to counsel and check the latest developments on state law. Given this really rapidly changing landscape surrounding reproductive health, even if your practice or situation doesn't directly have to do with abortion services, it's become apparent that a lot of the state laws targeted at abortion are drafted, so broadly that they also capture activities such as fertility treatment, human tissue, and things like embryo storage, transfer, and disposal. So if you deal with any of these issues, make sure to keep up with those regulatory developments and feel free to reach out to me and Kayla if you ever have any questions. And next slide. Oh, actually this slide. So next, I'm going to touch briefly on the topic of medication abortion. So in January of this year, the FDA modified its risk evaluation and mitigation strategies, called REMS, for the use of mifepristone, which, for those of you who might not know, is the medication used to terminate an early pregnancy through 10 weeks gestation. Now, during the COVID-19 public health emergency, the FDA stopped enforcing a prior requirement that mifepristone be dispensed only in person. And this modification to its REMS permanently removes the in-person dispensing requirement, which will allow healthcare providers and patients to continue to utilize telehealth platforms to receive mifepristone by mail. And these, that's not to say that these modified REMS, they will still have some strict requirements in place. Basically, it still requires that any healthcare provider who prescribes the medication is certified in the REMS program. It requires that all dispensing pharmacies will be required to sign a pharmacy agreement form, and all patients will be required to sign a patient agreement form that informs them of the risks or complications associated with taking the medication. These modified protections may, however, end up being limited as states are attempting to enact legislation that is more restrictive than these FDA regulations. And many states across the country have actually already enacted legislation that mandates in-person dispensing of mifepristone. And so while there's currently disagreement amongst the federal courts on whether the FDA regulation will preempt any materially adverse state law, so if you are in a state that you know has been heavily legislating around reproductive health, it's going to be really important for you to contact your counsel to review this in detail. Okay, so for those of you who are closely following the developments in women's health occurring at the congressional level, just as there are many bills that are being passed at the state level, a new bill has been recently introduced in March of this year to Congress, titled the Women's Health Protection Act of 2023. Now, this proposed bill would protect a person's ability to determine whether to continue or end a pregnancy, and also to protect a healthcare provider's ability to provide abortion services. It remains to be seen whether this bill will proceed and pass through both houses of Congress, but we wanted to at least put it on your radar as something to watch, as it may potentially impact women's health in the future. Now, as you also know, McGuireWoods Consulting is our consulting team who we work really closely with on these types of legislative issues, and they have a really strong presence on the Hill and are tracking these bills closely. So if ever of interest to you, you want to better understand the bill at a more granular level, or you want to get a sense of how likely it is that a bill might get passed, please don't hesitate to reach out. We can put you in contact with one of our colleagues. Now, in February of this year, the Department of Health and Human Services, alongside several other federal department agencies, issued proposed rules that would amend regulations regarding coverage of certain preventative services under the ACA, the Affordable Care Act. Now, current regulations include exemptions for optional accommodations for entities and individuals who have religious or moral objections to coverage of contraceptive services. While the proposed rules would leave in place the existing religious exemption as well as the optional accommodation for contraception, it would rescind the moral exemption rule. And instead, the proposed rule establishes a new individual contraceptive arrangement that individuals will be able to use to still obtain contraceptive services, but at no cost, directly from the provider or facility that provides contraceptive services, and without any involvement on part of the objecting entity. While there's no update yet on the status of this proposed rule, our team is prepared to provide an update through a client alert whenever new information becomes available, so just keep an eye out for that. But for now, this is just another thing to keep our eyes on. Okay, now fertility treatment. Infertility affects about 10 to 15% of couples in the U.S. Despite the significant need, though, for these fertility services, fertility care in the U.S. is inaccessible to many due to the high costs involved in obtaining treatment. And fertility services are often not covered by public or private payers. But as of today, 21 states plus the District of Columbia require that private insurers cover some fertility treatment, but the state laws differ, on the types of treatment that might be included, whether that's IVF coverage or fertility preservation or both, and under what circumstances. So there are still some significant gaps in coverage despite these laws. For instance, only one state Medicaid program covers some type of fertility treatment, and no Medicaid program covers in vitro fertilization or artificial insemination, which means that most patients who seek fertility treatment are forced to pay out of pocket, which can cost them, possibly 10 grand. And because of this high price point, when insurance doesn't cover treatment, fertility care is inaccessible for a large portion of the U.S. population. Also, it's just worth noting that these state rules only apply to state-regulated health insurance benefit plans. So if a business alternatively chooses to self-insure its employees' coverage, the plan is regulated by the federal government under the Employee Retirement Income Security Act, or ERISA, and such, those state mandates are not going to apply. Despite this, we are seeing an increase in employers, especially large employers, opting to include coverage for infertility treatment as part of their group health plan, likely in the hopes that doing so might benefit their recruitment and retention of employees. Now let's talk a little bit about assistive reproductive technology, or ART. So ART treatment involves the retrieval, manipulation, storage, and application of gametes, embryos, and gonadal tissues. In 1992, after an increased use of ART caused some concern about the quality of the ART information that patients received, Congress enacted what's called the Fertility Clinic Success and Certification Act. This act mandates that all ART clinics report their success rate data to the federal government in a standardized manner. But despite the requirements of this act, there still appear to be some gaps in the law, which has led to providers engaging in fraudulent behavior. And as a result today, at least 12 states have enacted what they are calling fertility fraud statutes. And basically these statutes impose penalties on past misconduct by participants who are engaged in the ART process. The federal government seems to have also taken recently a particular interest in this issue, as a bill has been introduced to Congress that would establish a new federal criminal offense for knowingly misrepresenting the nature or source of DNA used in ART or in assisted insemination. Now, in the wake of Dobbs, many who are involved in IVF and other ART treatments have expressed the need for some clarification into the definition of legal personhood for purposes of determining whether an embryo might be considered a legal person. Because if that's the case, fertility clinics would need to reimagine their current protocols and the way they manage embryos. And this becomes a particular concern when we're talking about pre-implantation genetic testing, storage of unused embryos, and even the disposal of embryos that are unlikely to contain reproductive potential. Now, while there's not much of an update in the egg freezing and storage space, while there are many state laws and regulations on egg freezing, storage, and transfer, there's no pending legislation that would standardize the process at the federal level. So just stay mindful, pay close attention to the state law developments in this space. Another really hot topic recently has been the issue of maternity deserts. So a maternity desert is a term used to describe counties, which are often located in rural areas, that have limited or absent access to maternity health care services, either because of a lack of services altogether in the area, or perhaps a woman's inability to access that care. Maternity deserts ultimately prevent people from accessing prenatal, delivery, and postpartum care in a timely manner. And to put this into perspective, a 2022 report from the March of Dimes found that 36% of U.S. counties fit the designation of a maternity desert. And a woman who lives in a maternity desert is actually 60% more likely to die. This is a statistic that is hard to even comprehend, I think, and it seems to luckily be gaining some attention from politicians and lawmakers. For instance, the White House recently published a blueprint for addressing maternal health disparities in the United States, and often cited maternity deserts as one of the major issues in maternal health. Now, from an investor's perspective, this also may be an area worth looking into, as it's not only a very needed service by women all over the country, but also the increase in maternity deserts and this growing attention from society and the federal government on the issue may even present an attractive investment opportunity. So just some food for thought. And the next slide. Now, although there is not a recent update in this space, we wanted to at least touch a bit on surrogacy for those interested. We're still not seeing any federal law that would materially impact or target surrogacy, so it's really up to each individual state to determine the enforceability of surrogacy agreements and whether a surrogate may be compensated or not. There are two distinct types of surrogacy. There's traditional surrogacy and gestational surrogacy. Traditional surrogacy is the result of artificial insemination of the surrogate mother with the intended father's sperm, making the surrogate a genetic parent along with the intended father. Whereas gestational surrogacy is an arrangement where an embryo from the intended parent or from a donated oocyte or sperm is transferred to the surrogate's uterus, meaning that the surrogate that's carrying the child will actually have no genetic connection to the child. Traditional surrogacy is not permitted in many states, and gestational surrogacy is the more commonly used method of surrogacy today. Like most other things we will have discussed during this webinar, state laws on surrogacy tend to differ, and most states don't have actual legislation that's explicitly permitting or prohibiting, different types of surrogacy and under certain circumstances. Rather, most of what we understand about surrogacy law has actually been shaped by the courts. And while surrogacy agreements are enforceable in most jurisdictions, there are certain nuances within each state and what's allowed. So, for instance, where a state such as California permits compensation to gestational surrogates, grants pre-birth orders, and allows for both parents to be named on the child's birth certificate, other jurisdictions that are less surrogacy friendly, such as Michigan, prohibit all forms of surrogacy contracts and even goes as far as to, subject any party who enters into a surrogacy contract for compensation. They might be subjected to fines and or criminal penalties. The majority of states, however, fall, somewhere in between in a sort of gray area. And we are seeing a trend of states becoming more accommodating and accepting of gestational surrogacy agreements. So if you are somehow involved in surrogacy arrangements, make sure to check in with counsel to ensure that you're not located in the state where surrogacy has been outwardly prohibited by legislation, and make sure that you understand the types of surrogacy arrangements that are legally appropriate and enforceable in your state. And finally, I'm going to talk about the changes that we are seeing and some of the questions surrounding Impala. Now, following the Dobbs decision in July of 2022, the Department of Health and Human Services issued guidance to, quote unquote, remind hospitals of their existing obligation to comply with the Emergency Medical Treatment and Labor Act, Impala. This remains true even when abortion is the stabilizing treatment that's necessary to stabilize an individual's emergency medical condition, for whether that's for further treatment or transfer. The department also addressed a letter directly to healthcare providers confirming the department's position that physicians must provide such stabilizing treatment irrespective of any prohibition under state law. The guidance here points to Impala's preemption language, indicating that when there's a conflict between state law and Impala, if during a medical screening examination on a pregnant person, the provider ends up finding that there is an emergency medical condition, then Impala is going to preempt any state law that prohibits that treatment, and the provider's under an obligation to provide the necessary stabilizing treatment, or alternatively, to transfer the patient to another hospital that may provide such treatment. This indicates that the department recognizes that there's an issue with any state law that prohibits abortion without also including an exception for the life of the pregnant person, or generally any state law that ultimately draws an exception more narrowly than Impala's definition of an emergency medical condition. And so, despite the department's efforts to clarify a provider's obligations under Impala post-Dobbs, recent court decisions have led to further uncertainty regarding the interplay between Impala obligations and these state abortion laws that we're seeing. These court decisions may, possibly preview a longer-term legal battle between the federal government and states seeking to restrict abortions in the context of emergency care, which is mandated by Impala. Now, any hospitals or physicians on the call who are trying to kind of balance these obligations should discuss any concerns they have with counsel and stay on top of any updates that may come from both the department and the courts. And because Impala compliance is primarily assessed based on available documentation, it's always really important that the treating physician's documentation includes documentation on the medical screening examination and the necessity and appropriateness of the stabilizing treatment to treat the emergency medical condition. Okay, so for HIPAA and privacy concerns, there's really only one major development that deserves a larger discussion, and that is the proposed rule by the Department of Health and Human Services that deals with the HIPAA privacy rule. This proposed rule is aimed at providing greater privacy protections to patients who receive reproductive health care services across the U.S. Following the Dobbs decision and in response to the state law abortion bans, President Biden ended up signing 2 executive orders directing the department to consider revisiting the privacy rules under HIPAA. And the purpose was to strengthen the protection of patients' sensitive information related to reproductive health care services and also to bolster provider-patient confidentiality. And in response to Biden's executive order and rising societal concerns, in April of this year, the department ended up issuing a notice of proposed rulemaking that would modify the privacy rule under HIPAA. And if finalized in its current form, it would modify existing standards under the privacy rule by expressly prohibiting uses and disclosures of PHI, protected health information, for criminal, civil, or administrative actions against regulated entities or others if they legally, under the specific circumstances, sought, obtained, provided, or in some way facilitated reproductive health care. So at issue with the existing privacy rule, according to the department, is that it permits, but under no circumstances does it prohibit, covered entities from disclosing PHI to law enforcement officials or others without the individual's written authorization. Now, among other things, to try and rectify that issue, the proposed rule would, first, it would require an attestation from the requesting party that the information they're seeking is not going to be used for a prohibited purpose. Second, it would modify some of the requirements for notice of privacy practices. And third, and perhaps most importantly, it would clarify when PHI may be used or disclosed by regulating entities and when such uses or disclosures are actually prohibited. Specifically, regulated entities would be prohibited from disclosing PHI that is either provided outside the state where the investigation or proceeding is authorized and where the healthcare service is lawfully provided. Second, if the treatment is protected, required, or authorized by federal law, regardless of the state in which that healthcare service was provided. Or third, it was provided in the state where the investigation or proceeding is authorized and the care is permitted by the law of that state. And on the slide, you'll see there are some examples that might help clarify those specific situations. Now, the comment period for this notice of proposed rulemaking closed on June 16th of this year, and there's, as of now, no update, but we do plan on publishing an updated client alert when that information does become available. If finalized as proposed, though, the department suggests that all affected covered entities either adopt or alter their existing policies and procedures, enhance security of IT systems that might contain PHI, and actually retain certain employees on the new requirements, and that they revise certain business associate agreements that may be affected by the rule. And with that, after a long breath, I will hand the mic back over to Kayla.
Thanks, Sydney. So as everybody on the call probably realizes based on the slides, Sydney was covering most of the updates with respect to the hardcore regulatory issues impacting this space, and then she's handing it over to me, and I'm going to cover some of the changing dynamics among different providers in the space, some of the transactional developments that are likely to impact you as buyers, sellers, joint venturers, different people on the phone. So one of those major developments are group practice growth and development. There are a couple topics we're going to cover. One is just the changing environment for group practices and what we're seeing from a very practical level. The second is the demand for ancillary developments and how significant numbers of regulatory regimes impact those developments. And then the last is the demand for group practice compensation to recognize this changing environment and some of the things that we're seeing based on different people that are operating in the space. So the first is the changing group practice employment environment. This is going to apply to nearly every provider that is on the phone today. You're probably seeing it in your practice, perhaps seeing it in other practices around the country, whether you be an OBGYN, a fertility physician, a cancer doctor, or many other subspecialties that affect women's health. But what we are observing is there tends to be an increase in corporate and hospital employment of women's health providers. So it is less common today than it has ever been in the past that there is independent physician practices without hospital affiliation or without private equity or other strategic backing. And you can see here on the slide that OBGYNs specifically are one of the highest percentage in the country of different subspecialties that are actually seeing corporate employment. And what I mean by that is private equity-backed entities or other strategic-backed entities, so like the Optums of the world, for example. This data does not include hospital employment. If we were to include hospital employment, it would be even higher than the percentage that you're seeing here. And so what does that mean? We are seeing undoubtedly a demand for increased ancillary access and development. There is a focus by physicians that are coming out of residency as well as physicians that are developing their own practice to have access to state-of-the-art ancillary care, state-of-the-art technology, and the ability to facilitate that and provide that to their patients in a very convenient manner. The other is we're seeing more requests for innovative compensation. So it used to be the case that we would see very commonly salaried physician structures with little or no investment in ancillary compensation. That is just not the case anymore. We are seeing lots of innovative compensation models, which we will talk about in a minute. The other is complex referral relationships, and these come in the form of two ways. One is we are seeing greater physician interest than we have ever seen before in investments in technology, in investments in lab and imaging, in investments in joint venture relationships with health systems. And those all have increasing complexity, increasing regulatory issues to navigate, and so that's a trend that we see on and on. The next is on the shortage of providers. And Sydney talked about this a little bit when she touched on maternity deserts, and that touches the OBGYN space. But within women's health, it's broader than that. It is your OBGYN shortages in places like Las Vegas. There is severe shortages of fertility physicians across the country. Wait lists for patients to get into those providers are very high. And so as we continue to see that trend, it puts additional pressure on the business aspects of practices and hospitals and other providers to practice a little differently, to leverage things like mid-level providers in a clinically appropriate way so that they can be serving populations in places like these maternity deserts that Sydney touched on. And then the last is, and this has been on the radar but continues to really skyrocket, is the escalating use of technology and demand for data. That's coming from a couple of different places, in my opinion. So it's coming from payers. There's a huge push toward a value-based care environment. The government is making it incredibly attractive with some of their new policy positions related to value-based care programs, but also certain exceptions from a federal Stark law and a federal anti-kickback perspective to allow providers to move into value-based care spaces. Nearly every women's health provider that I speak to are in the early stages of that development. They don't have very fulsome value-based care initiatives yet, but the first step is technology and data. And what we are seeing is it is very challenging to have the level of technology and the level of data that you need to go to payers, you need to go to the government to negotiate the relevant value-based care initiatives if you don't have a certain scale. The other thing that we're seeing that is being very COVID-driven is just sheerly the patient demand for technology. They want to be able to get their care in an easier, more convenient way, and they got used to it in COVID, and they'd like to keep it that way. And so we're seeing lots of innovative providers in technology, and the practices that we're seeing that are able to partner with those technology companies, invest in that patient-driven clinical access point have been really successful, and I think we'll continue to see that changing group practice environment. So the single thing that I'm asked about most frequently by clients and asked about how to develop what is the latest and greatest is on ancillary development and then their associated regulatory considerations. More than ever, patients and providers expect integrated ancillary models, whether it is from affiliations with their health system partners, whether it's with inside their group practice, a one-stop shop for patient access. We are seeing that demand primarily in mammography, genetic testing, lab, and some in DME, depending on the specialty. So we included a couple of slides here on the deck just so we can talk a little bit about what are the pressure points, what are we seeing, what are the developments. So many of you, to the extent that you are in imaging or an OBGYN business, are probably very familiar with mammography and certain other imaging services. One thing that we get asked very frequently, and I think is an area of intense focus, is to what extent can physician providers participate in this ancillary service? And the overarching rule is that it's not impossible if it's not through a group practice, but it's challenging, and it needs to be structured in a very thoughtful and regulatory-minded way. And so to the extent that you are looking at an imaging or other mammography arrangement with referral sources or other providers, I would encourage you to consult your counsel, talk to them deeply about the options at both your individual state law and at the federal law. But a couple things to be mindful of. One is the physician self-referral law generally prohibits, unless an exception applies, a physician having a financial relationship with an entity that offers imaging services that are considered designated health services if that physician both refers and has a financial relationship with that entity. The simplest pathway to be able to deal with the Stark law tends to be housing these ancillary services within a legitimate group practice under Stark. Many of you probably know what I'm talking about on the phone, but that's something to be aware of, to really dig in with your counsel if you're considering one of these arrangements, because they can be really sticky. Mammography in particular is sticky because some services are considered designated health services, some services are not, depending on whether or not they're diagnostic or not. So just being really mindful of looking at that state law. The other point is on the federal anti-kickback statute. The anti-kickback statute applies both to providers and non-providers to the extent that there is anything exchanged in consideration for referrals. I'm not going to go over all of the points of that law on this call. I think everybody on the attendee list is probably quite familiar with it. It's just to please be mindful of it and be mindful that it exists. I want to also include an asterisk on state laws because we're seeing a really evolving climate across the country in different state laws that impact self-referrals or kickbacks. And everyone is not just like the federal statute or just like the state statute from another state. So please be very mindful when you're looking at rolling out mammography or other imaging arrangements that you're looking at those state laws because they are very, very different. The other thing to look at are your contract's billing restrictions. There are some payers that we are seeing increasingly restrict where certain services may be provided and where they are reimbursable in order to be provided in that site. So knowing your payer contracts, knowing the restrictions on billing before the service is provided will really help both you and your patients. And then the last thing on mammography is state fee splitting laws. So with respect to fee splitting, that can apply if you have a provider-to-provider sharing of fee arrangements. It can apply in scenarios in which you have a provider to a non-provider fee sharing arrangement. So be mindful of those. Look into those with your counsel because it is very common that we will see structures where a radiologist, for example, is coming in to read a mammography a mammogram that has been done, and then when they are doing so, they are receiving a certain portion of the overall billed amount. Sometimes these state fee splitting laws can come into place, and you just want to be really cognizant of it. The next is on pathology and clinical laboratory services. I'm not going to hit Stark again and kickback again because those laws are going to apply to pathology in the same way or very similar ways that they apply to mammography that we just discussed. I'm just going to hit a couple of other things. First, as a corollary to the kickback point that we were discussing, please be cognizant of the contractual joint venture risk when you are looking at pathology and clinical laboratory services. There is a real increase right now in the market among different providers coming into group practices or coming into health systems to set up pathology arrangements, and then they will share some of the risk of setting up that arrangement. They will have contractual guarantees or contractual purchasing obligations. That in and of itself, in my opinion, is not a de facto issue from a kickback perspective, but it needs to be reviewed very closely to the extent that anyone other than the provider that is doing the billing for the particular laboratory services is taking on risk in the setup of the arrangement. That's something that sometimes hasn't gotten a lot of attention, but there have been a number of settlements on it from an OIG perspective. There have also been a number of circumstances in which we have seen the government looking into that area. So I just put that as an asterisk from a kickback perspective to everybody be aware of. There's a couple of other laws when you're setting up laboratory arrangements that continually have settlements and continually have updates. So I just want to put them on your radar here. So first is ECRA. We commonly hear the response that if I do not take government pay, I can do X, Y, or Z. That is true in some states. Some states do not have similar kickback and state Stark law rules that would implicate an arrangement if you are not taking government pay. But in this situation, in the lab context, there is a new law called ECRA that prohibits remuneration in return for referrals for lab services, and it is not applicable to only government pay. So I just wanted to include that as an asterisk for the lab context, because we're seeing that commonly be an area of interest, and there have been a couple of settlements around that we want people to be mindful of. The next law that flies a little under the radar, and we've seen continual interest in this with respect to pathology arrangements in women's health and otherwise, is the anti-markup rule. So this is the structure of, if you have a group practice, the group practice is billing for laboratory services, they are receiving the benefit of laboratory services, and then they are outsourcing those laboratory services to someone that is not performing more than 75% of their time on behalf of the group practice. That can implicate the federal anti-markup rule, and there can be a requirement that there be no benefit of that billing that is retained by the group or the provider, and rather that benefit is passed to the provider that is actually doing the laboratory services or the read. There are state law equivalents of the anti-markup rule, so it's something to be mindful of. One other way to comply other than having someone be your pathologist or your technical lab provider 75% or more of their time is also they can read on site at the site where your particular test is ordered. So that's something to be mindful of. Many women's healthcare providers that I speak with aren't aware of that particular rule or aren't really focused on some of its nuances. So we just wanted to point it out because we are seeing some interest around that area. I think most of you all probably know a lot about CLIA, so I'll skip over that here, but you can reference it on the slides. And the last thing is in reimbursement challenges. It is being very common that we are seeing across different questions from clients, different transactional structures, that payers are restricting lab referrals other than to people like Quest, LabCorp, and others. So please be mindful before you set up one of these lab structures that is a changing update that we are seeing. So the next is on group practice compensation. I mentioned earlier that the compensation arena has only gotten more complex since I have started to practice in women's health and even law in general since I started. It is more common that physicians today are looking for opportunities to share in ancillary services, have innovative ways to share in the overall profitability of the company. And so we just wanted to include a couple of slides here. I'm not going to spend a lot of time on this. I just wanted you all to have it for reference as you go back and you look at some of these arrangements. From a group practice compensation, within group practices, we've included a few options of the way that group practice compensation can be split on a compliant basis. And then the piece I really wanted to focus on is it's very common now that we see management companies that are managing physician practices. And we are constantly asked the question about whether or not you can do certain innovative distribution models through the management company that you may not be allowed to do with respect to compensation within the group practice. The general rule is if you can't compensate someone at the group practice level in that way, you also can't do it with respect to distributions coming out of the management company. So when you do, if there's anybody on the phone that is looking at these innovative models where you have a group practice and you have a management company, be very mindful about the way in which you are doing group practice compensation, and that is complying with all of the requirements from a federal and a state law perspective. But also within the management company, don't forget to really focus in on those distributions, focus in on those compliance elements as well, because that's something that we're seeing of being more interest to the government across the board, and we just need to be very mindful. A couple of quick anecdotes on both OB groups and fertility groups on compensation. Remember that OB groups may have a specific exception for group practice compensation that they can rely on. Many OB groups take less than 5% of designated health services payable by government pay, and they have a special exception that they can split compensation differently than, for example, an orthopedic group might be able to. So if you are an OBGYN group on the phone, please make sure that you are aware of that special exception. We're always happy to talk about it, or you can contact your counsel about it, but it is something to be aware of that you can rely upon. The other component is for fertility providers, they typically only accept TRICARE and maybe just a very small amount of TRICARE. So from a federal Stark law and a federal anti-kickback perspective, they largely will not be regulated by those laws with respect to their compensation. Rather, those practices should spend a significant amount of time focusing in on their individual state laws, because those particular practices often are outside of the governmental statutes. Next, in our last couple of minutes here, I'm going to cover some different alignment strategies and also a couple of antitrust points. On alignment strategies, we've included a few different options here because what we're seeing is an ever-increasing demand for ways of clinical providers to align in the marketplace. And they are going to be required to do that to continue to meet value-based care initiatives, to continue to meet patient demands. And so this is probably one of the very significant questions we get internally and one of the very significant developments that we continually see. So there's a lot of traditional joint venture methods that probably people on the phone are very familiar with. So things like ASCs and urgent cares. We see those very commonly between hospital providers, group practices, and even sometimes management companies in the market. Co-management agreements, we've seen these be more common for OBs in their laborist programs for health systems and endocrinology programs. It is common that local independent OBGYN groups are entering into co-management agreements with particular health systems, whether in their own market or across the country, to work on improving their laborist programs, improving their clinical outcomes, and they're being compensated for those medical directorships, clinical components, and other time that they're spending on call coverage and others. So be mindful of that if that's something you're looking at and thinking about. It's something that we're seeing as an emerging trend. Again, it was very common 10 years ago. It's becoming even more common again now. A couple of these other points we'll just leave here as a potential other structures so that we can still hit a couple of minutes on the antitrust components. But we want you to be really aware of these because we think that they are an emerging area that continues to be more common. Of course, many of these have been around for a long time, but we're seeing a significant number of providers in the marketplace mixing and matching. So they might have a value-based care arrangement together and a co-management agreement and a joint ventured surgery center. So that level of overlap between these different alignment structures we've seen as an increasing trend. I'm not going to go over these on the call, but we're just leaving these for your consideration on different regulatory issues when you do enter into alignment structures, just to be very mindful of these particular things being true. These will help the compliance elements of any joint venture arrangement. But just remember, these aren't the be-all, end-all. Still need to deeply look at things with counsel and make sure that everything is compliant. But these are a starting place. The next thing, and I'm just going to spend 5 minutes here on the antitrust climate for the health systems on the phone in particular, and for the larger practices and potential investors that are looking at exits of women's health businesses. The antitrust climate is more intense than it has ever been in the healthcare space. We see the government looking very critically at healthcare private equity. We see the government looking very critically at hospital expansions and developing a larger footprint. So it's something to be aware of in absolutely every affiliation strategy, every transaction, everything that's going on in your business. Be very, very aware of this changing environmental point. The first point I'll hit quickly is the HSR filing changes. So for you on the phone that don't know what I mean by HSR, that's the Hart-Scott-Rodino Act, which applies to large transactions over a certain threshold, it changes year to year, but we're usually talking about $90 million of potential purchase price or value. And there have been historically a pretty simple process to go through FTC review for those type of transactions. There are a new rule that was published in June 2023 with comments due now on September 27th of this year that significantly increases the burden on HSR filings and notifications prior to a significant transaction. We think that those filings are going to be a lot more burdensome based on the commentary that's been issued to date by the FTC. The cost to file them is going to be very significant, probably by a factor of about 4, and there's going to be a lot of document retention and production requirements. I'm not going to go over all of those on the call today, but if you all do have a transaction coming up that you believe could be impacted by HSR, please do not hesitate to reach out, because those are going to be very significant obligations coming up here, likely toward the end of the year. The next thing that everyone on the phone should be aware of, big and small, it doesn't matter if your transaction is tiny or your transaction is the biggest one that will happen in the U.S. this year. There are new healthcare state law filing requirements that are going into place for healthcare transactions across the country on a state-by-state basis. Each of these are very bespoke. Some of them impact management companies, some of them impact group practices, some of them impact hospitals, some impact all of them. But this is just a quick chart of what states have these new laws that are coming into effect. And they're largely targeted at transactions and other arrangements. When I say other arrangements, you could include joint ventures in some circumstances, where providers are coming together to provide care that the government has an interest in reviewing. So, for example, New York passed one that went into effect earlier this year, and it has a pre-closing notice requirement of 30 days for certain healthcare transactions in excess of a $25 million in revenue threshold. So if you're operating in New York or one of these other states that have one of these state law filing requirements, really need to be mindful of these updates. Please reach out. We're always happy to talk about them, but they are very bespoke and they're very individual, and they are not the same state to state. So determining whether you have to file or you don't have to file is very important. And please don't look at them only in the transactional context. It can also be triggered in certain affiliation contexts. And the last point that I'll talk about is antitrust compliance overall. So people in the healthcare space are used to having robust HIPAA compliance, robust fraud and abuse compliance. You probably have very robust OSHA compliance. You name them, there's a lot of compliance programs. But what we've found is there are very few healthcare providers that have a robust antitrust compliance policy. The FTC is more focused on continuing to make sure antitrust compliance is happening at healthcare providers, so we wanted to include a slide on this. This can really help protect an organization for a number of different ways. It can allow for early detection of issues so that those can be addressed and quickly remedied. It also is a deterrent effect. If people know what they're supposed to and not supposed to be doing, it can help ensure that people are not getting the company into hot water from an antitrust perspective. And then if there is an issue, the fact that the company has had an antitrust compliance policy and program that is being actively implemented assists if you do have to talk with governmental agencies, you do have to negotiate a situation in which you have not been fully in compliance. So that's just another plug for antitrust compliance because of the current environment that we are seeing. We would really encourage any healthcare provider to review this component. And please, again, reach out if you have any questions. We're always happy to assist. And with that, that is it. Thank you all so much for joining us. We really appreciated having you. We hope you will join us for other healthcare webinars that McGuireWoods hosts, but specifically those from our Women's Health Working Group. And again, please reach out if you are interested in participating or joining the Women's Health and Wellness Investment Summit in Charlotte on September 27th or the Healthcare Finance and Growth Conference on September 28th. We would love to have you and happy to get you registered. Thank you.
Thanks, everybody.